videos that can help people with some of the issues regarding the Ohio prison system. And today's topic is how to prepare for a parole hearing. The state of Ohio does have a parole packet that you can download on their website. Just Google up the ODIC. There'll be a section in there to download the handbook. Really, that should be memorized. Inmates should have a copy, and I don't know if they do. I know the state's not going to issue them one. They may allow it in there or not. But I'm just going to read the basic part on the front of it so that you have some idea. And this was updated in January of this year. Again, on the introductions there, the Ohio Revised Code, RC 5149, period, 02, created the Adult Parole Authority, APA, as it is known to many of us, in the Division of Parole and Community Services of the Department of Rehabilitations and Corrections. The Ohio Parole Board is a section within the APA pursuant to RC 5149, period, 10. Board consists of up to 12 board members. I think there are 11 at this time, and they're looking to appoint another one. That's kind of ridiculous to have that many for 4,100 people under the old law and about 4,000 under the new law that has to see the program. And we're talking about lifers, of course. Under the new law, under the old law, it could be anybody that was convicted of a crime because they have to see the parole board, okay? Including the chair. The chair would be one of the 12. The members are appointed by the director of the DRC and must be qualified by educational experience in correctional work. That's something we've been trying to work and change and get ordinary people to sit on the parole board. That top our work, including law enforcement, prosecution of offense, advocating for the rights of victims of crime, probation, of parole, and law. The victim representation appointed after September 30th, 2011 are subject to term limits of 2 6-year terms. The director is the primary decision maker with the governor, must appoint one individual to the board who is a victim of crime, members of a victim's family, or who represents an organization that advocates for the rights of victims of crimes. Of course, we do not have an inmate advocate. We are promised by the governor's office that we're going to put one on, and they have not. The board determines release suitability of eligible offenders serving indefinite sentences to decisions that promote fairness, objectivity, and public safety, and are responsive to the concerns of victims, members of the community, and other persons within the criminal justice. We see there's nothing mentioned about treating inmate fair as well during their hearings. Board currently consists, it says in here, 8, but that's 11 members who primary duty emails conducting release consideration hearings on all parole eligible inmates. These hearings are held every month from the institutions and generally include majority of board members conducting a personal interview. I would like to stop right there. They're supposed to have 7 board members at a hearing. They're all from Central and from all different parts of the state, and they've been averaging anywhere from 2 to 4. So that's incorrect. They can't legally vote without 7 vote members in there. Then they're supposed to conduct a personal interview with each parole eligible inmate, and they do not do that. These hearings are usually conducted using video conference technology. If parole is denied, then inmate is not suitable for release, the board establishes a subsequent hearing date and making release decisions. The board is mandated by Ohio Administrative Code OAC 512 1-07 to consider certain factors in determining an inmate's suitability for release. Although the outcome of all parole hearings is public information, institutional parole release hearings and deliberations are close to the public. However, the board offers participation in a public conference at 15 conference days each month, providing the victim and their representatives and offender families and other representatives an opportunity to exchange the information with the board prior to an inmate's release consideration hearing. A lot of this stuff they don't follow, but there's a lot that the family members can do to get ready for the parole board hearing along with the inmate. I've seen the help, and not very often, but I've seen inmates talk themselves into a parole or talk themselves out of a parole. But that's not very often. Pretty much, I think the parole board members already have their minds made up before the inmate goes in front of them. Some of the things that the family members can do and the inmate is, I would say within 3 months before the hearing, and it should not be any later, letters of support need to go to the parole board on support of the inmate. Any letters as possible, such as a pastor, aunts, uncles, friends, and make sure that email or mail to the parole board along with sending a copy to the inmate, and it should go. All letters should go in the institutional file by the inmate. So you got 2 so far. The inmate needs to put it in his file, his institutional file. Letters need to be sent to the parole board, and I'll give you the address afterwards for that. And then, of course, the family member is allowed to have a conference, a family conference, it's called with the program. And you need to call them at least 2 months prior to that for the family conference. And make sure you take anything to that hearing in support of the release of your loved one. So that would be that's 3 things so far. Well, 2 things so far that we'll have family conference, the inmates parole, and as of now still, if they're going to recommend parole, goes to the full board hearing. They're talking about live streaming the hearings. We are totally opposed to that. We need to protect the privacy of the inmate, their family, and the victims as well. And if you're live streaming, you're going to get a lot of negative letters sent in on the inmate from the public. So we don't want that. We did ask for videotaping, and the videotaping is to protect the inmate and the staff alike. You know, if the inmate say this happened during the hearing, and the court said no, it didn't. It's on tape. And that should not be released to the public, whether the news without all sides agreeing to it, such as the inmate's side, the victim side, and the DOC. But if one is opposed to it, it will have not be released at all. So after during the full board hearing, they will make a decision on parole or not. After they hear the hearings from the prosecutor attends. Here they usually go through Skype. The family member has time to testify. And the people where the inmate would live, they will really ask some questions never have elf on the house. And one of the pro members said, you mean not even at Christmas time? She said, well, maybe at Christmas time. So the inmate was not approved to go to her house because they consider her lying, which I think was accidental, but she doesn't normally have alcohol in her house. So there's a lot of things that the family members can do to get involved in the pro process.